I'm Tom Axworthy, Public Policy Chair at Massey College, and I welcome you to this discussion on the ethics of bail reform. I want to begin by acknowledging that Massey College is built on the lands of many Indigenous people, uh, including the treaty lands of the Mississauga Credit and the traditional territories of the Huron-Wendat and the Haudenosaunee peoples. So today, bail and bail reform is certainly one of the most contentious issues in our judicial and correction systems. It makes headlines frequently. It's been the subject of significant reports by police associations, the Civil Liberties Association of Canada. Uh, Public opinion polls show that there is great concern about crime in general, but also bail as part of that overall system. And Canada's premiers just a few weeks ago, in fact, sent a letter to the Prime Minister demanding further reflection and reform on our bail system. So we are meeting with a very distinguished panel to talk about a very contentious issues. So I want a brief introduction. I'm going to give a brief introduction and then throw it to our panel and begin the discussion. And then we're on the YouTube Massey channel, and that will be open to questions to the Massey audience as well. So Mary Jane Bennett is a very distinguished litigator with many years' experience in Manitoba and British Columbia. I believe she started her career actually as a staff lawyer for legal aid, so probably has known about bail issues right from the first time that she graduated. And she has made many contributions to the public policy program here at Massey. Peter Slowly is the visiting fellow at Massey, our change maker in residence, and the former police chief of the Ottawa police force. And Peter is working with our public policy program, in fact, to organize a conference on organized crime and artificial intelligence and what to do about it, September 27th. So this discussion on bail is kind of a precursor to a day-long discussion on organized crime and how we can deal with that. And then Kate Mitchell is a junior fellow at Massey. She's a CJD candidate at the University of Toronto Law School. And she does much work on the issue of prisons and corrections, and is also a scholar at the Trudeau Foundation. So we're delighted that you have joined us, Kate. So, Mary Jane, let's begin with you. Can you just outline the rough framework around bail for our audience? It, of course, is a charter right, uh, but it involves area of what is just cause when our judges and justices of the peace have to make bail decisions. So I'd like to go to you for your first comments.
Yeah, the, I mean, if we go back to the common law, there were two reasons. Initially, it was simply you could deny bail for if there was a concern about a flight risk of an accused. And as we progressed in the 1940s, you saw in the common law as it developed that where there was a concern for the safety of the public, that would be also considered or should be considered in bail applications. But what was happening in Canada was up until 1972, our Bail Act was completely missing any guidelines. So all it said was that a judge can or a magistrate can admit an accused to bail. And the bail was going through the magistrates' courts, and so what the findings were was that most people were being detained. and not granted bail, that those that were poor were definitely not being granted bail, and that something had to be done. And there began this movement to do something about the bail system, where 90% of people arrested and police were not were arresting rather than issuing summons, were being kept in jail. So you've got the groundbreaking new legislation being the 1972 Bail Reform Act, introduced by then Justice Minister John Turner in the under the Liberal government of Pierre Elliott Trudeau. And it was groundbreaking. There's no question about it. It introduced two grounds to which an accused could be detained. And the first was whether he presented a flight risk, and the secondary ground was considered public safety and what to do with repeat offenders. And as we progressed forward, you can see this dialogue developing between the courts and the legislature in terms of whether these are sufficiently covered. And I know from myself there was this always this concern: what exactly is the public safety, and how far can the Crown go to denying bail on that grounds? In 1997, the Justice Minister McClellan, under the Chrétien government, tightened that, introducing a tertiary ground. Now, the courts, there was some concern as to how far they should go, but the tertiary ground definitely covered issues that remained a concern to the government. You've seen since then that in the bail reform by Justice Minister Jody Wilson-Raybould was very poorly received, so much so that in British Columbia, the government in 2022 basically said that it should not be, it should be ignored, and that it didn't sufficiently cover repeat offenders and violent crime. And the editorials in newspapers were saying that it's clear that that bill was insufficient to deter crime. And moving forward, then in January of 2024, the government, the Justice Minister David Lametti, introduces a very tough on crime bail, where there are reverse onuses for a number of offenses, indictable offenses, offenses with weapons, terrorism charges, and security charges, and intimate partner offenses. So you've got very restricted bail, and now this call for more restrictions. I don't know, I cannot see how that could ever be more restricted than what it is. And we are not fighting the law that was introduced by earlier by Justice Minister Wilson-Raybould. We're dealing now with a very tough on crime bail law introduced in January of 2024. So they say that hard cases make bad law, and I'd say that the recent tragic death of Tory Dunn by an unprovoked, terrible, violent crime was, we should be looking elsewhere. Is it the judicial system that was at fault? Was it the Crown Attorney? What problems are there in the system that is causing it? It's not, as Pierre Poilievre says, the fault of the Prime Minister Justin Trudeau's bail laws, as he's quoted as saying. It is we've got to look elsewhere for answers.
Good. Well, thank you. Peter, Mary Jane had just pointed out that there have been many changes to the bail system, a couple fairly recently in the last few years. So certainly, police associations across the country have been vocal about the bail issue, and police forces have pointed out that there seems to be a real issue with repeat offenders. I just read a report from Peel that in a swing on auto theft, they arrested 26 suspects or something recently, but more than half of those suspects were out on bail on another offense, and that is something that you hear from police forces often. So what is your perspective on where we are on bail and policing?
Well, thanks, Tom, and for you and your team for putting on this series. I was scribbling notes frantically as Mary Jane was giving an excellent, succinct history on bail reform in Canada. So I suspect I will learn as much or more than I contribute. Let me start with a question, Tom. Certainly, police associations, including the Police Association of Chiefs of Police in Canada, have in the past year been pushing the government for a review of the current of the bail act because it stood a year ago, and there have been changes that they've been able to influence, and that is a reasonable level of advocacy for important associations representing both frontline police officers and police executives, police chiefs. Um, Most recently, in December 4th, 2023, the Canadian Association of Chiefs of Police put out a response to Bill C-48, which is the federal Liberal government's most recent and, as Mary Jane pointed out, most significant tough on crime approach to bail reform. The Chiefs of Police Association said there was a need to keep violent and repeat offenders who pose the greatest threat to public safety and officer safety. And I repeat, public safety and officer safety. In fact, over the last 18 to 24 months, there have been a number of high profile deaths of citizens minding their own business. There have also been a number of high profile deaths and serious injury to police officers doing the business of public safety and public service. The Chiefs of Police Association goes on to say that Bill C-48 does not address all of its concerns around the problem of violence in society. While they applaud the addition of, for instance, domestic, family, and partner abuse into areas for pretrial custody and reverse onus bail conditions, they recognize that societal violence is a complex issue that Bill C-48 cannot alone solve. No more than policing alone or the justice system can alone solve these problems. So we've been in this sort of pendulum back and forth, starting in 1972 across liberal and conservative governments. Tough on crime, soft on crime, smart on crime is really where we need to get to.
Yeah.
So on that note, let's look at some statistics. And this is relevant for our discussion about where have we been, where are we now, and where do we need to get to. Canada right now ranks as the highest country among the US, the UK, and Canada. We're the highest in terms of pre-trial custody at 38.7%. Let's just call it 39%. The next highest is the United States, almost half lower at 22%. And then the UK, again, another half lower at 11%. So Canada at 39% has the highest level of pretrial custody. What that means is people are in jail without actually having been convicted of a crime. Yes, for very important reasons, as was laid out in Bill C-48 and as its predecessor in 1972 under John Turner and the Pierre Trudeau government. Flight risk, public safety issues, more defined and even more determined now to keep people in jail even prior to a conviction. But Canada is at the top of the pile by a long margin. Let's also remember, historically and right now, disproportionately, the people in the justice system, whether in pretrial custody or facing post-trial incarceration, are disproportionately Indigenous, Black, and visible minorities. Increasingly, and again, this is a historical thing as long as I was a police officer going back to the late 1980s, the number one reason people are in pretrial custody is because not of the original crime they committed, but because of some failing to comply with the court orders around their pretrial charges. So they failed to show up in court, failed to appear, they failed to comply with a condition of their release, failed to comply. It's those charges that end up being the main reason why ongoing rates of pretrial custody are going higher and higher. Last but not least, let me go back to smart on crime. We have too many people in the justice system. It's actually clogging the system. Important cases that need to be tried in front of a judge and sometimes a judge and jury, are being backed up because of the immense number of court cases, including pretrial custody cases, most of which, again, are judicial crimes, not crimes committed against citizens. We need more off ramps out of the system. We need more pre charge diversion for cases that don't need to get into a court and tie up valuable court time so that serious domestic assaults, sexual assaults, gun and gang and drug related crime and homicides can actually get the time they need in order to be resolved appropriately, ethically, and lawfully. We need more off ramps at the post charge diversion level. So charges have gone in, Crown lawyers have looked at the cases, and they find there are options, largely through third party not for profit agencies, where these pretrial offenders can then go and do some form of customer service, rehabilitation, and recidivism reduction in order to avoid the need for a full trial. And those that meet that level of assessment and commit to that recidivism program are able to do so, and again, free up the courts and free up literally hundreds of thousands of dollars of taxpayer money year over year on an individual case. And last but not least, for those that actually do go to jail, convicted of offense, we need this country to take a leadership role, not the leadership role of pretrial custody, a leadership role globally around recidivism reduction. So when they come out of jail, as 99.9% of them will, they will not reoffend. In fact, they'll be a contributing member of society. I certainly have much more to say, and I look forward to good questions. I have much more to learn, and I'm looking forward to the next presenter, Kate Mitchell.
Thank you, Peter. Kate, Peter's made the point. I'm sure this surprises many listeners, viewers of the program, where we know from public opinion surveys that the public wants the system to be tougher on crime. And yet, Peter had some statistics that Canada already is ahead of many other countries by putting people in detention while they await trial. So while they're in detention, I guess that also raises the issue of what happens to them there in terms of any kind of training or the change to try to make them lose their criminality. Has anything that you've heard from our previous speakers, would you care to comment on that? And then also tell us a little bit, because I know you've spent a lot of time studying this, the issues of prison and what happens to people who are actually in detention. Are we doing enough good, or are we just locking them up?
Well, thank you so much for having me here, Tom. It's such an honor to be here alongside Mary Jane and Peter. And I think to really have a serious debate about bail reform, we have to take seriously the perspective of the people who are in this system and the really profound human cost of our current bail practices. And so that's what I want to do in this first round, because I think it helps to shed some light on where our bail system is going wrong and why tightening bail laws isn't necessarily the solution to protecting public safety. And so I wanted to start with a quick example to give that perspective. An individual, Maciej Timkowski, stopped by police on October 15th, 2018, and ultimately arrested and charged for a few different offenses, including possession for the purpose of trafficking cocaine and fentanyl, and a couple firearm-related offenses. At the time of the arrest, he was going through extreme substance abuse problems. He had lost his family, children, job, and house. And he attributed his offending to trying to support his substance abuse. And he was initially denied bail and only released months later following a bail review. And he was released under really strict conditions. He was under house arrest. He couldn't leave his house without his parents. And he had a number of conditions, including not being able to have a cell phone or a digital device more generally. And while he did make some positive strides pursuing some treatment, he ultimately couldn't continue to pay for the substance abuse treatment. And eventually he relapsed. And September 2020, he was stopped and charged once again, and this time with possession for the purpose of trafficking fentanyl. And there was no bail this time. It took over 2 years for his charges to be dealt with. And during that time, he was held in the provincial jail system, where he endured some incredibly restrictive and degrading conditions. He was in a small cell. Often there would be 3 people in a single cell. He endured frequent lockdowns. He had limited access to clean bedding and cleaning supplies. There was no yard time for months at a time. Access to showers was limited. He saw a great deal of violence and was fearful for his safety at times. He faced some really intrusive and degrading searches, and he was placed in the hole, that is, segregation, which is a practice that we know now is very destructive. And he was held there under particularly filthy and demeaning conditions and even developed a very serious bacterial infection. So, the point I really want to make here is that there's nothing really unusual about Mr. Dymkowski's story. Frankly,
Mhm.
people in the criminal justice system, like Mr. Dymkowski, are disproportionately marginalized people. Peter alluded to this as well. And I just want to add to that that they're often experiencing substance abuse disorders, mental health conditions, housing instability, and poverty. And people come into conflict with the law because we don't have a society that provides the supports that many of these individuals in crisis need: healthcare, mental health services, affordable housing, social services, etc. And so, really, in our bail system, we're ending up with a lot of people who are in crisis. And at worst, they end up getting locked up, which compounds a lot of their problems. And at best, they're getting released, often after significant delays. And then they're thrust into the community, where they typically have very little support. And now they're required to live under these really tight, restrictive conditions. And so I think, is it really any surprise that people like Mr. Dymkowski sometimes do end up back in the system when, in certain respects, they've been set up for failure? And I want to be clear that the solution here, it's not just to tighten our bail laws. Obviously, first off, constitutional rights protect the reasonable right to bail, and we have to honor those commitments. And second, Mr. Dymkowski's story, it really illustrates the high human cost of our bail practices. Conditions in pretrial detention are restrictive, degrading, violent, unhygienic. And the reality is there's not much, if any, rehabilitation that's actually going on there. And the human cost isn't just inflicted on the people in pretrial detention. Their children, parents, friends, communities all suffer as well. And I think I'll end just by saying that locking up large number of people, it's not the best way to be improving public safety. And as a caveat to this, we have to remember that pretrial detainees are still people. And when we talk about public safety, we need to account for the crimes that occur in our jails, in our prisons, and the safety of those individuals. But even leaving that particular issue aside, reports and studies have shown that time in prison increases the likelihood of future criminal behavior. When people are locked up, they lose homes, jobs, potentially children. They miss out on medical appointments and important opportunities. All of these things that can make future run ins with the law much more likely. And people also experience violence and trauma in custody, and the unfair and inhumane practices that they experience can make them a lot more mistrustful of government as well. And so, really, a lot of people are leaving our jail system a fair bit worse than when they went in. And as Peter pointed out, we need to keep in mind that the overwhelming majority of people in our bail system are going to leave jail or prison if they end up there and re enter our community at some point. And so we have to keep our eye on the big picture here and ask ourselves what is going to make a safer society overall. And I'm going to suggest that's not tightening bail. It requires providing more social supports. It requires honoring our commitment to reasonable bail and trying to limit the destructive force of incarceration. And for those who we ultimately do incarcerate, if we're going to take that extreme step, we have to do much better by them and improve the conditions within our system. So I think I'll stop there, and I look forward to some more questions in the second round.
Good. Well, thank you. I want to raise then, because all of you, in one way or the other, have been saying that tightening the bail system is not necessarily the correct way to go. Peter says we should be smart in dealing with crime. Uh, And yet, if the panel is raising doubts about the toughening approach on bail, which the current government adopted in C-48 itself, and which our premiers have said is not tough enough. They've just sent a letter to the Prime Minister a couple months ago saying that it's not enough. What is the disconnect then between the facts and what you've been telling us on this panel and the fact that at very, very high levels, the go-to area is tighten up even more? I'm trying to understand what's the disconnect between what experts are saying and what public and politicians, how they are responding. Mary Jane, let's start with you, because you also raised the history of attempts to change the bail system. So what's going on here? Why is there such a disconnect?
Okay, I can say initially I agree with everything the other panelists have said. I thought that both presented exactly what needs to be done, and Kate very eloquently on the, the problems with allowing bail to be unrestricted. The point of my presentation was that um, the the fact of the matter is there is no there is no need for further legislation, that it is all there already, and this cry for more legislation goes against the facts of the matter. Number one, when prior to Bill C-48 in January of 2024, there was extensive communication with all 10 provinces and 3 territories on what needs to be done. And this, the solution in Bill C-48, which was of mere months ago, was adopted and endorsed by all 10 provinces and 3 territories. So I fail to understand what else further could be done when months ago they said that this was sufficient. And secondly, the stats that Peter Slowly introduced, I think are all accurate. That we are a very jail oriented type of system, and that what we need is smarter moves forward. And in that regard, you know, in 2012, the average stay for somebody in bail, that was denied bail in a remand center was $183 a day. It's currently within 9 years, in 2021, it was found to be $409 a day. So, like, let's say that today it's about $500 a day to keep someone in remand. Is there something better we could do with that kind of money? And the suggestions that have been put forward by both Kate and Peter are absolutely appropriate. We could have, as some studies have said, a dedicated dedicated bail courts where people become proficient in these kind of things, these kind of matters, rather than being part of a larger docket and part of actually what becomes, from my experience in court, a bit of a sausage factory where you're just pummeling through these matters and not giving undue attention to the matters that Kate mentioned, such as what is this going to do to an accused, and are there any other intelligent options available? So I think we're all on the same page here. There is tough on crime. We don't have to worry that people are getting out. I mean, the chief of police in Vancouver, Adam Palmer, recently mentioned that there are 11,000 arrests per year in Vancouver. And yes, every once in a while of those arrests, there will be a problem, and there will be a tragedy that occurs. But of 11,000 arrests, there is something that could be done within those numbers. And I think when you take into account the cost and the cost on the lives of these people, alternatives should be available.
Okay, Kate, Peter, respond on this.
Thanks,
Anything to add?
Tom. Maybe I'll just jump in where Mary Jane just took us.
Yeah.
And I think we all understand this instinctively, but sometimes it gets lost in the crises that we've been talking about. The justice system is an incredibly imperfect system. All the other systems that lead into that are themselves incredibly imperfect. Social services, public health, education, because they all deal with the most imperfect subject matter in the entire world, human beings. So trying to get perfection out of the system is impossible. So the pendulum moves back and forth depending on what the politics or the crisis of the moment is. Let me go into the numbers that Mary Jane just updated for me, because my last numbers were it cost about $75,000 to $100,000 per year for pretrial custody. Mary Jane's numbers puts that at $150,000 a year
Yeah.
for pretrial custody for each individual in the system. Just reducing that by 10% produces $150 million that can be spent on upstream. So where's the disconnect, Tom? The disconnect for me is we have a imperfect but flexible and moving midstream bail reform program. What we have is an underfunded and siloed and therefore disconnected and an inefficient human services ecosystem with the justice system, public health, public education, social services, and I'm going to add in the not-for-profit sector more broadly. They are not properly funded. They certainly are not coordinated in their efforts. And so our ability to address upstream issues like the social determinants of health that Kate talked about in her presentation, like crime prevention programs that are chronically underfunded and underinvested, particularly by the policing system, but more broadly, we have an ineffective upstream program to reduce the funnel of people that come into contact with the law and certainly come into contact that puts them into the justice system. Then we have the downstream problem. Again, both Kate and I have talked about that we have few, if any, really effective rehabilitation programs, and we languish terribly in the area of recidivism reduction, which actually is a major crime driver in terms of trends year over year, decade over decade. So I think we need, again, not only to be smarter, we need to consider the entire upstream, midstream, and downstream process. We need to stop talking exclusively about justice system institutions, police, courts, and corrections, and broaden the conversation to the human services institutions that should be working together at all of those levels, upstream, midstream, and downstream. I'd be happy to unpack that further, but I'd love to hear what Kate has to say.
Great, thanks. I would just echo a lot of what Mary Jane and Peter have already said. And one thing I just want to elaborate on as well is I think this misunderstanding within the public about what the right to reasonable bail really means. We have a lot of people who don't see the bail system as being restrictive enough and capturing enough people. But for the lawyers who work in this system and many of the people who work with people on bail, it's actually the opposite problem. The problem is that we're actually capturing too many people in this bail system, and there's a real risk aversion problem. Creating a bail system where nobody reoffends is problematic. There's simply no way for judges and justices of the peace to know with 100% certainty what will happen, who will go on to reoffend, or who can be trusted on bail. The only way to avoid any issues with people on bail would be to simply stop the practice. And that's completely inconsistent with our constitutional values. Respect for the right to reasonable bail, it means that we have to accept a certain degree of risk and not treat every instance of someone who breaches their conditions as an indictment of the entire system. Our goal needs to really be to create a system where people are making the best possible decisions at the time of release and giving due regard for public safety and also the right to reasonable bail, and having a society that provides the resources that are necessary to prevent people from offending in the first place or falling back into reoffending while on bail. And again, it means that there's always going to be some risk. And incidents happen, including very tragic ones, as the murder in British Columbia emphasizes. And I think that these are moments where it is good to reflect on our bail system, but we need to resist the urge to have these knee jerk reactions to tighten the system. Instead, we need to be looking at whether that was the right decision at the time based on the available information. And I don't think we have enough information about those proceedings to be able to say that right now. And we also need to look at whether, as a society, we're doing enough to stabilize people who are in the community and ensure that the public is safe.
Well, this then raises another question. You've all talked about differing pieces of potential uh, required actions to deal with crime, um, and yet we have a a public. I think Kate just talked about a knee jerk reaction, but many in the public instantly go to tough when bad things occur, and they're encouraged by many politicians. It's a mutual admiration society to toughen up the system, and yet you've all raised large pieces that need work in terms of trying to streamline the justice system, the administration of the justice system, um, programs to uh, while they are in detention to try and help people get on a decent track. Can I ask each of you, perhaps an unfair question, but if it isn't toughening the system, which was just toughened in C48, putting that aside, if it isn't toughening the legislative framework, where would you put your time and efforts then in terms of the reform? We're talking about the ethics of bail reform. So if it ain't toughening, what should it be? So let's start with you, Peter.
Thanks, Tom. I was kind of hoping you'd toss us somewhere else. I'm not going to answer your piece around toughening, but hopefully my answer will contribute to the theme you're on. There are some micro issues. I've certainly laid out a big picture ecosystem kind of thing, and that just makes policy wonks love it, and the average Canadian hate it. But here's the reality. We've got a generation of senior Crown lawyers, including my cousin with 30 plus years in the Ontario Provincial Crown's office, that are retiring, incredibly experienced, hardworking, and have a huge capacity to manage massive caseloads. And there are some capable people coming in to replace them. But there's just not enough, and there's not enough experience. So we're seeing Crowns coming in on a Monday morning after a busy weekend in Vancouver, in Edmonton, in Calgary, in Winnipeg, in Toronto, St. John's, and they're coming into massive stacks of case files, of show cause hearings, increasingly with reverse onus on them. They've got defense counsel and legal aid themselves relatively junior, inexperienced, and doing it at a pretty low cost to society, who themselves are not adequately briefed on the, as Kate talked about, the human being in front of the court. Never mind the charges, never mind the investigation, never mind the weight of evidence. So the entire thin veneer of a decision around pretrial detention is fraught with even more risk when you look at the resources that are at that thin metal layer on the Crown side, on the defense side. And again, those cases are not held, presided over by experienced full-time provincial court judges. They're justices of the peace. So we have a very weak set of links at that very critical mid portion of the justice system, around the point where the most vulnerable members of society have a on-ramp into the justice system in jail, or a potential off-ramp opportunity. So I think those are areas that we could look at some risk of going down a rabbit hole on technology. The genie's out of the bottle. There are disproportionately risky technologies that are available and are actually in use right now within our justice system, certainly other justice systems around the world, that we need to consider, including AI, machine learning tools that could help to get through some of the more mundane aspects of case preparation, case review, and connect the dots to create a more rich picture, not a biased picture, but a more rich picture of the human being in front of the court. Some of those technologies could be applied to produce a benefit to society, to the individual before the courts, to the victims who have been offended against, and to the courts and the justice system themselves. So those are my opening thoughts around tough on crime.
Good. Okay. Mary Jane, where would you put an emphasis then? If it isn't rewriting legislation, what to do? Because I don't think anybody here on the panel would disagree that we do have a crisis, certainly in public fears about safety and the responsibility, the ability of the system to respond. So, what should be next on the reform agenda?
Well, I think that we could begin by redirecting the funding that we pay to keep people in jail to better use. And so that would be dedicated bail courts, that could be people that check up on the accused, or um, uh, other kind of community supports. I'd be definitely interested in determining what people would think would be the appropriate response. I'd love to engage with the public on those kind of issues rather than on this put them in jail kind of attitude, and this wrongful um, suggestion that has emerged in the last month or so, that we're not tough on, that the laws are not sufficiently tough on crime. The laws are there. The laws are very tough on crime. And what we need to do now is understand that that's the case, and how can we best ensure the safety of the public. And it is not by, I don't know what Mr. Poilievre has in mind, because there is section fundamental rights in the charter, that section of the charter which deals with fundamental rights, and it is the right of somebody that is legally innocent to not be denied release without just cause. So, I mean, he has a massive burden there. Is he going to ignore the Constitution? How is he going to work around that fundamental democratic right? And so I do not understand where he's going with this. Maybe what he will do is cut back legal aid, as his counterpart in Danielle Smith did in Alberta. Now she's given it a reprieve recently, but the funding by the federal government, because it's a co-shared agreement with the government and provinces and territories, is $200 million. That's pittance in a federal budget. And so, is he going to make sure that the poor, I mean, that's the judicial system deals with, I would say over 90% are the poor. And are we going to say that the poor are denied a lawyer, whereas the rich can have a lawyer? I don't know where he's going with this, because we have the tools in place, and it's time to redirect them elsewhere to, bail courts, and better public safety, and helping the accused with addictions and with their mental health issues, because that's legitimately what is behind all of this, and deal with that rather than simply keeping people behind bars.
Kate,
Yeah,
where would
thanks. I
you
once again going to
where
just
would
echo
you
what Peter and Mary Jane have said. And I really like Peter's line about being smart, not necessarily tough. And to kind of echo a point we've already talked about, the main area I would focus on would be those social supports that are necessary to keep people from committing offenses and to stabilize them in the community when they're on bail, so they're not falling back into a cycle of crime. And we also, I think, need to do a lot more to improve the conditions in our jail system. And I think finally, we need to really make sure that we put the resources into the courts to make sure that they can make the best decisions possible at the time and have the information that they need. Incarceration is a very destructive force, even short periods of time. And I think it's really important that we tackle one pervasive issue, which is delays in that system. Culture of adjournment is a big problem for a lot of defense counsel, and getting people out is exceptionally difficult. We need to make sure that we can reduce the amount of time people are in that destructive carceral environment without the need for it. And I think we also need to provide the resources to ensure that decision makers can make the best decisions possible in light of the concerns of the public on safety and the charter. And both Peter and Mary Jane have alluded to a lot of these issues. And I think that there needs to be a lot more attention paid to the resources of courts to ensure that we do have enough bail courts running, legal aid to ensure that counsel have the funding they need to properly advance their client's case and to bring bail reviews and other proceedings when necessary, and to deal with the issues surrounding that. And I think that there's also a big element of public awareness and judicial training that's also needed on the charter. Again, going back to this idea of risk aversion, that's really the more pervasive problem for a lot of people who are in this system. And I think that we need to do a better job educating the public and the people in our system about what the right to reasonable bail really means. And we need to follow through on our constitutional commitments in the charter.
So just so I'm clear, when you talk about risk aversion, people in the system, the prosecutors or the judges or the justice of the peace, their default position is to put people away because they worry that they will be attacked if something bad occurs, if the individual's on the streets. Is that what you're talking about in terms of risk aversion?
Yeah, absolutely. The default position is to deny release when there's anything more than a zero chance of somebody hurting the public or undermining public safety. And that's not a philosophy that's ultimately consistent with our charter. And that's why even a lot of people and advocates say that it's not necessarily about the legislation. Like we can make changes like removing reverse onus provisions. But the problem is that in practice, there really is a reverse onus in a lot of cases. The system is so risk averse that prosecutors, police officers in this system, the judges and justices of the peace, and we need to do a much better job bringing our decision making in line with the charter and accepting that there will be some people who ultimately breach when they're on bail, and that's not a symbol that our system is ultimately failing. It's just the inevitable result of a system committed to the right to reasonable bail. You can make the best decision at the time based on the information you have, and it's not going to be perfect. We can't accurately predict exactly who is or isn't going to breach. We just need to try to do the best at the time, consistent with respect for the right to reasonable bail.
Um, can I
Yes.
can I add a couple more things?
Sure,
I'm just
jump in.
grateful for these two panelists. They keep pinging in my mind with things that just get me thinking here. Um, First of all, we just heard about the conditions in jail. Actually, we've heard about it repeatedly from Kate, and I'm grateful for that. I remember as a young constable dropping off people on pretrial custody detentions at the old Don jail. And I can tell you, if you've never been into an 18th, 19th century prison, and there are many of them operating across this country, but the Don jail was a revelation for me as a young police officer and as a young man and as a still young citizen of Canada about how we were not getting it right. And that is 35 years ago. Now, we've done a lot to invest in the corrections facilities, but not nearly enough. And the vast majority of them operate exactly as Kate had described earlier on. These are overcrowded facilities with not enough guards, not nearly enough healthcare, social work care, and built environment care to look after people with highly complex issues, not just their criminogenic factors, but the majority are in with some form of mental health and or addiction issue, or they have been traumatized along a spectrum of social determinants of health issues over the course of their lives. So these are complex and very fragile individuals. Even some of the most violent and notorious offenders have that level of complexity that requires a level of investment that has simply not occurred in this country, never mind most of the other G7 countries.
Sorry.
So the next point I would go to is around uh, the convictions levels. This government, in particular, in its first term in office, made cannabis and marijuana use legal, and they are pushing, with a lot of support from several provinces, to legalization of other uh, drugs, decriminalization towards legalization of other drugs. I am neither for nor against. I'm still being informed upon those positions. But what I can tell you, though, is if you've made a decision to decriminalize, then you also need to make a commensurate decision for eliminating those criminal offenses off the records of individuals. Because the buildup of those records also are a major factor in a reverse onus or show cause hearing. So again, if you're going to layer on the tough, you got to layer in some fair along the way, and that'll get you closer to smart. Lastly, and I touched on this in my previous comment, is technology. Let's go back to the legal aid lawyer who is, 6, 7, 8 files deep on people facing pretrial custody hearings that they've never met before. They need data. They need information. They need context on that individual. They need data, information, and context on the charges that they're facing, and they need data, information, and context on the risk portfolio that presents to the justice of the peace who has to make that decision. The justice of the peace needs the same thing. The crown lawyer needs the same thing. But our system is so balkanized that we can't put healthcare data, social services data, educational data, human data into that criminal file. So we're simply looking at a one-dimensional image of a very complex human being facing a very complex set of circumstances, where literally a life-changing decision is going to be made. We do have the technology. We certainly have the data. We do have the technology. And that's where I think machine learning and AI, properly developed, open box, not black box algorithms that are kicked and stress tested by people like Kate Mitchell and Mary Jane, can actually help all parties in the justice system to advance a more just and smart system.
Well, that leads into a couple of questions and comments from the audience. Peter, you've just been talking, as have other panelists, about the poor or the marginal who are such heavy recipients of the attention of the criminal system. One of the questions from one of the audience, though, is that could any of the panelists share an analysis of how the bail system works for white collar crimes versus the traditional crimes that we've been talking about? What about white collar crime? Are they treated differently? Anyone have a comment on that?
Well, I can start off is definitely first thing they'll have a lawyer who will be paid for, and
Mm-hmm.
I don't know. When I was working at legal aid, you'd go into the lockup and you'd get a list of the people that you were going to see that morning. It could be up to 22 people that were arrested overnight. And
Wow.
you would have an interview with them very quickly. You would stand in line as the Crown was dealing with the 100 other matters on the docket, and he'd briefly tell you, I'm opposed, and you didn't know quite the facts of the case. But there is this need to get the accused out on custody because their job, their livelihood, even their ability. I don't think this has been mentioned. I might have missed it. That when you're in the lockup, you're or on remand, you have your inability to speak to a lawyer is completely deterred. You can't phone and have that kind of communication with a lawyer. And the fact of the matter is, when we're denying bail, I just thought this has got nothing to do with white collar crime, but there is another statistic: is courts have talked about before they will say that a charge is has been unduly delayed and must be stayed. There's a 3-year period that involves there, so there is a very lengthy period of time that an accused can be in custody awaiting trial. But on white collar crime specifically, well, the first thing is you're going to have a lawyer. It will be delayed. There will be all sorts of motions and constitutional references that will delay matters. And, that really, they will, they're an exclusive club, those in the facing white collar crime. And we've seen that in terms of money laundering, how it took years before the government actually addressed it. Like money laundering involving tax evasion was dealt with under tax courts, for example. So yeah, the justice system, as it stands right now, is got kind of two standards: one for the poor in society, and another for white collar crime. So that's my answer, and it's kind of lengthy and maybe doesn't deal in detail with what your panelist the request was, but yeah.
Good.
Okay,
Anything else
thanks.
about the white collar crime, and then I'll refer to one last comment that someone from the audience made. And anyone, anything else about Peter?
Yeah,
Yeah,
just quickly, first of all, not surprised with the quality of the question from Shri, who's an amazing journalist and I think is part of our Massey community now.
yeah.
Um, um, so if we were, be careful how I say this, if the police had the resources, and I'll say police and national security, had the resources to focus on the massive, decades long tidal waves of fraud, white collar crime writ large, fraud more particular, and certainly since the pandemic, cyber enabled fraud on a scale we've never seen before. The court systems would be jammed 1,000 times more than they are now. The same problem would then MJ just talked about, Mary Jane just talked about, would happen is that we'd have a court system where a whole lot more people were represented by a whole lot more lawyers. Good for the legal industry. If you're into the criminal defense law side of things, your rate of pay and your client bill is going to go way up. So, unfortunately, or fortunately, depends on where you sit on the spectrum. If a crime happens in the public space or makes it to the public forum where media are talking about it, social media talking about it, a highly visible guns and gangs shooting, a random stabbing in Vancouver, a horrible domestic violence homicide that finds its way to the newspapers and rings out that righteous knee-jerk reaction, then you're going to have a very heavy discussion around bail reform, incarceration rates, the number of police officers and crowns, et cetera, et cetera. But when you've got a $1 trillion company that's been defrauded by $100,000 or even $1 million by someone who up until now has been an upstanding citizen and they can afford a lawyer and a communications expert, you're not going to get any sort of swift justice or any sort of relevant level of justice. So a critically important question around the larger, bigger picture of bail and how it provides more safety, more justice in a functioning Western democracy.
That could be another whole subject of another panel at some point on how we're dealing with the absolute tidal wave of the use of social media to defraud people. I should also have mentioned, because this has also come up, that among the many reports and so on the issue we're talking about, senior justices, of course, have also uh, tried to request and even demand reforms of the administration of justice, the appointment of judges, for starters. For some reason, there was enormous delays for the longest of time. The introduction of technology into our courts, where apparently we are well behind other jurisdictions. There's a whole separate issue, whether it be for bail or other crimes, which is how we actually are administering our courts and the huge deficiencies there. So we have come to the end of our time, and I just wanted to make this point. If any of our panelists have a quick response, and we're having a conference, as I said, on the 27th on organized crime, artificial intelligence, and how we respond to it. But I teach comparative politics, comparative public policy, and just is there some place that does it better comparatively? If is there a jurisdiction that we know on a piece of this that we think has got more of it right than Canada? Does one quickly come to mind, or are really all societies grappling with this issue? anyone, is there a gold standard in terms of dealing with these issues that we should be looking at?
Um,
Anyone know one?
at some risk, I think your latter statement is more correct. We're all struggling with this, north and south of the 49th. The UK is literally, because of the decrepit state of their jails, are literally releasing thousands and thousands of convicted persons back into the community because it is just, they cannot keep them in those conditions anymore. The United States, a bill that was brought in 2018, has released tens of thousands of convicted persons back into the communities. And some states are rushing ahead with that, and others are pulling back from it. Of course, the US elections are coming up. I think the only place where anybody slapped a gold standard on upstream would be Scotland and the government of Scotland and its approach, although it's gone backwards a little bit. Portugal, in terms of its approach to decriminalization, legalization, and upstream supports that Kate talked about. And still the Scandinavian countries, although again, they're backsliding on this a lot in terms of recidivism reduction, but no one's got it pulled all together, upstream, midstream, downstream. A lot of it is tough and soft on crime talk, and not enough of it is smart on crime actual doing.
Well, we'll end on that point. A comment was made that it's so hard to have informed discussion in the heightened polarization of Canadian politics now. But I want to thank the panel for their very informed discussion of this very hot issue. So thank you very, very much. I've learned a lot, and I hope our audience has as well. Thank you very much, and hope you can join us on our September 27th conference on crime. Thank you very much.